Something strange happened inside the Justice Department this week. Not subtle, not bureaucratic. The kind of thing that makes people in Washington quietly look at each other and ask, what exactly just happened? On Monday morning, the Justice Department did something almost nobody expected. They essentially backed away from defending a set of executive orders issued by President Trump. These orders targeted 4 major law firms, firms that had represented clients suing him, filed briefs against his policies, and generally made life difficult for him in court. The DOJ filed papers in federal appellate court saying they were dropping the defense of those orders. And for a few hours, it looked like the system had corrected itself. The firms involved were relieved. Legal analysts said it was a rare moment of clarity coming out of the department. The basic argument was simple. The orders raised serious constitutional problems, especially under the First Amendment. Punishing law firms because they represented political opponents, that's not exactly subtle retaliation. So the Justice Department stepped back, or at least it appeared to. Then, less than 24 hours later, everything flipped. Not gradually, not with some carefully worded reconsideration. They filed an emergency notice, pulling back their surrender and jumping right back into the fight. The speed of it raised eyebrows immediately, because courts don't usually see something like that. Lawyers don't typically abandon a position in the morning and then sprint back to defend it the same night. But that's exactly what happened. And by Friday, March 6th, the Justice Department had gone even further. They filed a brief in the appellate court that was, well, aggressive would be a polite way to put it. The argument they presented was sweeping. They claimed federal judges have no authority to tell the president what he can or cannot say. None. According to the brief, the executive orders aimed at those law firms qualify as presidential speech. And because they're presidential speech, courts supposedly cannot interfere with them. In other words, judicial oversight of those statements is off limits. The law firms that had been celebrating earlier in the week suddenly weren't celebrating anymore. Their reaction was immediate outrage. They described the reversal as legal whiplash, something they said they had never seen before in federal litigation. And people inside Washington's legal circles started asking the same question. What happened between Monday morning and Monday night? What changed inside the Justice Department in those few hours? The explanation, according to people close to the situation, is surprisingly straightforward. President Trump saw the news coverage. He saw reports that his own Justice Department had dropped the defense of his executive orders targeting those firms. And he was furious. Now, the executive orders themselves were already controversial when they were issued. The law firms involved had represented clients suing Trump, filed legal arguments opposing his policies, and participated in cases challenging his administration. From the president's perspective, they were adversaries. So the orders placed restrictions on them, limits connected to federal contracting and regulatory pressure that could hurt them economically. Legal scholars immediately raised alarms. They said it looked like unconstitutional retaliation, First Amendment violations, an abuse of executive power directed at political enemies. But the administration defended the orders anyway. Their argument was that the president has broad authority over federal contracting and regulatory policy, and the orders fell within that authority. The law firms sued. Several federal courts quickly expressed skepticism. Judges questioned whether the president could use executive orders to punish private organizations for protected speech or litigation activity. Eventually, the case reached an appellate court. The Justice Department was responsible for defending the orders there. And then, Monday morning, something changed. Career attorneys inside the department apparently reviewed the case and reached a conclusion. The legal position simply wasn't defensible. The constitutional problems were too obvious. The First Amendment concerns too strong. So they made a decision. They stopped defending the orders. That kind of move isn't unheard of. The Justice Department can decline to defend a legal position if it concludes the argument can't be sustained in court. It doesn't automatically mean they admit the policy is unconstitutional. It just means they won't continue arguing for it. For about 18 hours, that's where things stood. Legal experts praised the department for acknowledging constitutional limits. The law firms began discussing potential settlement paths. Court watchers assumed the case was basically finished. Then the president found out. According to people familiar with the events that followed, Trump was watching television coverage Monday evening when he saw the reports about the DOJ stepping back from his orders. The reaction, by all accounts, was explosive. He began calling senior officials at the Justice Department demanding explanations. Why was his own department surrendering to firms he viewed as enemies? People who heard those conversations say the language was intense, but the message itself was unmistakable. Get back into court, defend the orders, and don't worry about what the lawyers think. By Monday night, Attorney General Pam Bondi had received direct instructions from the president, and she made a decision that will probably define her time leading the department. She ordered the attorneys to reverse course. Immediately, inside the Justice Department that night, the atmosphere was reportedly chaotic. Lawyers who had spent days preparing the withdrawal were suddenly told to undo it. Supervisors who approved the original strategy were overruled, and the attorneys who had to file the emergency retraction were informed that their legal judgment no longer mattered. Political direction from the White House had replaced legal analysis. Some attorneys pushed back. They warned that reversing a filing within 24 hours would damage the department's credibility with the court. They argued that it would make the DOJ look like it was taking orders from the White House rather than exercising independent judgment. But the instruction didn't change. Retract the filing or resign. Late Monday night, the new notice appeared on the appellate court docket. It was exactly what the career lawyers had feared, a one-page statement saying the previous withdrawal was being retracted. No explanation, no legal reasoning, just a blunt declaration that the Justice Department was back in the case. Anyone reading it understood what had happened. This wasn't a strategic reconsideration. It looked like political pressure overriding legal judgment in real time. And the judges reading it almost certainly understood that too. Federal judges spend decades around lawyers. They know when attorneys are defending positions they believe in, and when they aren't. This filing made the situation painfully obvious. And the real test was still coming. Because by the end of the week, the Justice Department would have to explain its reversal, not in a one-page notice, but in a full legal brief. And what they filed next stunned a lot of people. By Friday, the Justice Department had to do more than quietly reverse course. They had to defend that reversal in a real legal brief, one that would stand in front of federal appellate judges and explain why the department had suddenly changed direction. What they submitted surprised even seasoned legal observers. The argument they laid out was sweeping. According to the brief, federal courts have no authority to control what the president says in his official capacity. None at all. The orders directed at those law firms, the DOJ argued, should be understood as expressions of presidential speech. And if something qualifies as presidential speech, courts can't interfere with it. That was the central theory. Even when that speech takes the form of executive orders that place pressure on private organizations. Even when those organizations claim the orders were issued in retaliation for protected political activity. The brief suggested that judicial oversight in that situation would violate separation of powers. Courts, it argued, simply cannot review presidential communications for constitutional violations. For a lot of constitutional scholars reading it, that claim felt extreme. Because taken seriously, the theory doesn't stop with law firms. It extends much further. If presidential statements are completely shielded from judicial review, then anything the president says or writes in an official capacity could fall into that protected category. And that raises uncomfortable possibilities. It would mean courts couldn't restrict or intervene when those statements target critics, or when they pressure institutions, or when they potentially punish individuals who oppose administration policies. The argument effectively builds a zone around presidential communications where judges have no role. For many legal analysts, that begins to look less like a standard separation of powers argument and more like a very large expansion of executive authority. The law firms at the center of the case reacted quickly. Their attorneys filed a response that barely hid their frustration. They walked the court through the timeline. Monday morning, the Justice Department steps away from defending the orders. Monday night, it files an emergency retraction. By Friday, it submits a brief arguing courts have no authority to question presidential speech. To them, the sequence itself was the evidence. They argued that such a rapid reversal showed the department was no longer making independent legal judgments. Instead, they said, it appeared to be advancing whatever position the president demanded. In their words, the Justice Department had begun functioning less like an independent institution and more like the president's personal law firm. That accusation landed heavily in Washington. Because the Justice Department has always had a complicated relationship with the White House, presidents naturally want legal strategies that support their policies. That tension has existed in every administration, but historically there were limits. Career attorneys inside the department could push back against arguments they believed were indefensible. Attorneys general could tell presidents certain legal theories wouldn't survive court review. There was usually some institutional resistance. Something different seems to be happening here. When Trump demanded the reversal happened. When he insisted the department continue defending the orders, the lawyers went back into court. There wasn't much sign of internal resistance surviving that moment. And the judges handling the case now find themselves in an unusual position. They're watching the Justice Department publicly reverse itself in the middle of litigation. They're being asked to accept a legal argument that dramatically restricts their own authority, and they have to decide how seriously to treat it. Some legal observers think the court may respond with a sharply worded opinion rejecting the government's position outright. Others suspect the judges might look for a narrower path, deciding the case on technical grounds to avoid escalating the political conflict. Either way, the episode has already created lasting damage inside the department. Reports from within the DOJ suggest morale has dropped sharply. Career lawyers who spent years building reputations for careful legal analysis now find themselves defending positions they previously rejected. Supervisors who believe the department still maintains some independence from the White House are confronting a different reality. And younger attorneys, the ones just starting their careers, are reportedly doing something quietly practical. They're updating their resumes. Because working in an environment where legal arguments change overnight, where positions can be reversed with a phone call from the president, creates risks for anyone trying to build a long-term reputation in the profession. The result is a slow talent drain. Experienced lawyers leave. New hires hesitate. And the institution gradually becomes staffed by people more willing to defend whatever argument is required at the moment. That shift matters because the underlying case isn't trivial. At its core, the dispute involves a basic constitutional principle. The government cannot punish private organizations simply because they engage in protected speech or litigation. That idea sits right at the center of First Amendment law. The 4 law firms involved represented clients who challenged Trump in court. They filed briefs opposing administration policies. In doing so, they were exercising rights that courts have long recognized as protected. The executive orders targeted them anyway. If the government can use executive authority to impose economic pressure on law firms for representing political opponents, that creates a precedent far beyond this one dispute. Every advocacy group, every legal organization, every business that publicly challenges presidential policies could become vulnerable to similar retaliation. That possibility is why so many legal observers are paying attention to this case. Inside the White House, though, the calculation may be different. From the president's perspective, winning the case might not be the only objective. Demonstrating loyalty inside the Justice Department could matter just as much. The rapid reversal sends a signal. It shows that when the president orders a change in legal strategy, the department follows. Even if the argument itself struggles in court, even if legal experts immediately criticize it, the message is about control. For the career attorneys watching all this unfold, that signal is hard to miss. They can see the boundaries of independence shrinking. They can see how quickly legal analysis can be overridden by political direction. And once that becomes the norm, it changes how the entire institution functions. Because every lawyer inside the building begins asking the same quiet question before making any recommendation. Will this survive the next phone call? Hi again, picking up where we left off. Now, the appellate court is moving toward a confrontation that many people in Washington didn't expect to see so openly. Later this month, attorneys from the Justice Department will stand in front of federal judges and try to explain 2 things at the same time. First, why the department reversed its own position within 24 hours. And second, why the president's executive orders that place pressure on private law firms, should be treated as protected presidential speech that courts cannot review. That is not an easy argument to make. Judges are almost certain to focus on the timeline. Monday morning, the department withdraws from the defense. Monday night, it retracts that withdrawal. By the end of the week, it's advancing one of the broadest theories of presidential authority anyone has seen in this area of law. Those kinds of shifts invite questions. The judges will likely ask why the original decision was made. They'll ask what changed between morning and night. And they'll ask whether the department's lawyers genuinely believe the constitutional theory they're presenting. For the attorneys standing at the podium, it's an uncomfortable position because they have two choices. They can suggest the earlier withdrawal was simply a mistake, something the department reconsidered after further review. Or they can defend the new argument fully, even though many observers believe it stretches traditional constitutional reasoning far beyond familiar boundaries. Neither option is particularly easy on a professional level, and that's why legal historians are already paying attention to this case, not just because of the underlying dispute with the law firms, but because of what it says about executive power in the Justice Department itself. If the courts reject the argument entirely, the episode becomes a warning about how politicized legal strategies can push constitutional theories into territory the judiciary refuses to follow. If, on the other hand, any part of the argument gains traction, it could reshape how presidential communications are treated in court. Either outcome carries long-term consequences. Meanwhile, the four law firms involved in the dispute are preparing for a prolonged fight. Even if the appellate court rules against the Justice Department's position, the administration could appeal the decision further. The case could eventually reach the Supreme Court. And until courts formally invalidate the executive orders, those orders remain active. That means the firms continue dealing with the practical effects, restrictions connected to federal contracts and regulatory pressures that affect their business. From their perspective, the legal battle itself is already costly, but it also represents something larger than a commercial dispute. Because the principle involved is straightforward, private organizations should not face government punishment for engaging in protected speech or representing clients in court. That principle has guided First Amendment law for generations. The administration's critics argue that allowing executive orders to target law firms for their litigation work would undermine that protection. The White House, however, has responded in a very different way. Officials there have not spent much time defending the constitutional details of the Justice Department's argument. Instead, they've focused on the law firms themselves. They describe the firms as partisan actors who use the legal system to oppose the president. From that perspective, the executive orders are framed less as retaliation and more as a legitimate response to political adversaries. They also characterize judicial review of those orders as interference with presidential authority. Supporters of the administration tend to see the dispute through that lens. Critics view it as something else entirely, which brings us back to the court. Within the next few weeks, the appellate judges will issue decisions on several procedural questions tied to the case. One immediate issue involves whether proceedings should pause while the broader appeal moves forward. If the court grants that request, the executive orders remain in effect for a longer period while the litigation continues. If the judges refuse, it may signal they view the government's legal position as weak enough that delay isn't justified. Either way, oral arguments are coming. And when those arguments happen, everything becomes public. Every question from the bench, every answer from the Justice Department lawyers. The entire exchange enters the official record. For Attorney General Pam Bondi, the moment carries obvious weight. Ordering the reversal placed the department firmly behind the president's strategy. Supporters see that as loyalty. Critics see it as sacrificing institutional independence. Inside the department itself, the consequences are already being felt. Some experienced attorneys are leaving. Others are staying, but working in an environment that feels very different from the one they joined. The long-standing idea that the Justice Department operates with a degree of professional autonomy has clearly been tested. Whether that independence survives this episode is an open question, because institutions don't collapse all at once. They change gradually, decision by decision, precedent by precedent. And cases like this accelerate that process. The appellate judges understand the stakes. Their ruling will determine more than just the fate of four law firms. It will shape how far presidential authority can reach when it intersects with protected speech and judicial oversight. In the end, the question is simple, even if the legal arguments surrounding it are not. Is the Justice Department acting as an independent institution guided primarily by legal judgment? Or has it become an extension of presidential strategy in court? The reversal that happened in 24 hours made that question impossible to ignore. Now the courts will have to answer it. And whatever answer they give will likely define how this moment is remembered, both for the department itself and for the broader debate over executive power.